Welcome to a Law Pro CPD, brought to you by Title Plus and the Toronto Lawyers Association.
Good morning. I'm Judah Stravchinsky, Director of Practice Pro, Law Pro's Claims Prevention and Risk Management Program. I'm speaking to you from Toronto, which is also where Law Pro and Title Plus and the Toronto Lawyers Association are located. I respectfully acknowledge that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It's now home to many First Nation, Inuit, and Métis peoples and is covered by Treaty 13 with the Mississaugas of the Credit. As this meeting is virtual, we're not all gathered in the same place. And for many of you, this land acknowledgement doesn't quite apply for the territory you're on. If that's your situation, we invite you to take time to learn and acknowledge the traditional territory and lands that you're on. As a resource, you can visit native-land.ca to research a location to find the appropriate territorial acknowledgement under the Resources tab, or contact a Friendship Center for guidance. I'd like to recognize the long history of all First Nations in Ontario and the Métis and Inuit peoples. We thank First Nations who lived and live in these lands for sharing them with us in peace. It's also noteworthy that we're meeting the week following Canada's second National Day for Truth and Reconciliation. Last week, the Advocates Society, the Indigenous Bar Association, and the Law Society of Ontario published a first supplement to their 2018 guide for lawyers working with Indigenous peoples. If you haven't come across either the guide or the supplement yet, I encourage you to review them. Both are available for free as online downloads, and they're full of practical information and tools around so many important topics. For example, they address cultural competency and trauma-informed lawyering, which we've mentioned in a range of Law Pro education events as skills that can help you effectively serve clients. The links to both the guide and supplement will be put in the chat for today's program. So thank you all for joining us for this Law Pro CPD event, Tips for Real Estate Lawyers. The event is presented by Law Pro's Title Plus in partnership, as always, with the Toronto Lawyers Association. Today, we're going to divide our hour and a half together into three segments. The first, we lovingly call Death and Taxes. We're going to describe issues we're seeing around what are called zombie deeds. That's the death part. Then we're going to review a few stumbling blocks that real estate lawyers and others come across around taxes and recent changes in tax policy that are going to impact on real estate transactions. Our second segment is going to be called Real Estate Binds. In these changing and challenging times, both buyers and sellers are finding themselves increasingly in tricky situations, and closing is not always guaranteed. We're going to describe what we're seeing and give you some tips to help your clients through these choppy waters, regardless of whose side you're on in the transaction. And third, for those of you who have come to our programs regularly, this will come as no surprise. We're going to review fraud, because there are significant frauds targeting real estate lawyers right now. We'll review ID frauds and wire frauds and review some tips to protect yourself and your clients. We've put together some timely resources for the program. For those of you who are live, you can find them on the link in the program chat. For those of you reviewing this program today, you can go to practicepro.ca/CPD, click on today's event, and click on the resources link to download them. Our speakers require no introduction. Their bios are in the program materials at the end, but I do want to take a moment to talk about my colleague, Ray LeClaire. As most of you already know, Ray is a diamond in the rough. He knows his real estate law, and he's an incredible speaker. He's passionate about real estate law and the importance of lawyers delivering excellent services to the public. I think these are some of the reasons why our friends at the Ontario Bar Association decided to highlight Ray's accomplishments this year by honoring him with their 2022 Award of Excellence in Real Estate. I wasn't able to make it in person for the award ceremony, due to COVID, frankly, and I missed it. And since we've all been in our pandemic bubbles and emerging at different times, not everyone here has heard about this wonderful career achievement. So I thought I'd take a moment, unbeknownst to him, and celebrate his accomplishments by sharing them. So félicitations, Ray. But there are no time for speeches, Ray. Instead, we're just going to ask you to keep doing what you do, talk about the latest in real estate law so that we can all benefit from your knowledge and tips. So let's dive in. Death, taxes, and first off to Lori. Thanks.
Hello, everybody. It is somewhat fitting that we are talking about zombie deeds in the month of October, which is traditionally a scary issues month. And as we, head into the run up to Halloween, there will be many a zombie on the prowl to get some candy on Halloween night. But a zombie deed is something different and continues to be a bit of a problem in real estate law. What is a zombie deed? Specifically, it's a transfer of an interest in land or property that was signed in the grantor's lifetime but not registered until after the death of the grantor, as if they were still alive. They have been used commonly as an estate planning tool historically, and a method to avoid the disclosure of the transfer of property from one party to another. The Ontario courts have been fairly inconsistent in their reasoning, and there are two significant cases on this topic. These are outlined in the materials. The first case was Winarski and Sproul that was decided in 2015. In this case, a transferor executed a transfer and left it with her lawyer, intending it to take effect immediately. Due to oversight, yes, we have heard about lawyer error on occasion, the transfer was never registered. Its existence came to light years later once she had died, unfortunately. In this case, however, the court found the zombie deed to be valid, since it was an attempt from the mother to give a gift of the interest in property to her son, and she had the capacity to do so when she signed the deed to make this gift. The court found that the failure to register the deed did not have the effect of legally voiding the transfer. So following this reasoning, it was accepted that for a zombie deed to be valid, the transfer and delivery of the deed must be unconditional, irrevocable, and stated as a gift. Narrow terms. More recently, in 2020, the court came to a somewhat different decision. That case is Thompson and Elliott Estate, and again, the zombie deed was accepted, but the reasons were very different, and there was some significant statements that are important in this case. So in this case, the judge did confirm that the delivery and not the actual registration of the deed or transfer is what determines if a joint tenancy has been severed. Evidence of delivery is that the party whose transfer it is, by words or conduct, expressly or impliedly, must acknowledge their intention to immediately and unconditionally be bound by the terms set out in the transfer. So in this case, the client did fully and unconditionally relinquish control of the documents to sever the joint tenancy and trusted that the lawyer would immediately register them. However, the judge also made some statements that, although it was allowed, it was done so with the intention that it would be immediately registered, and the court found that the lawyer erred, again, in registering the zombie deed, and that zombie deeds to transfer lands are generally invalid. In situations such as this one, lawyers need to bring an application requesting a certificate of pending litigation, a declaration of an interest in land, and a vesting order under Section 100 of the Courts of Justice Act. The court further stated that if detected, zombie deeds will be properly rejected by the Land Registry Office and they risk deregistration. Frankly, there is another remedy for the Land Titles Office, and that is that the Director of Titles can revoke your Teranet key if he detects or they detect that you have been attempting to register zombie deeds. So there are some risk management statements or lessons to be learned from this. One is to register a deed or transfer as soon as possible after you receive it, once all of the requirements are satisfied. Don't hold on to a transfer to register after the transferor's death. They're not valid for registration in Ontario and will be rejected or risk of deregistration if they're detected. A dead person cannot convey an interest in land. If you have a zombie deed, the proper course of action is to bring an application in the Superior Court of Justice and set out all of the material facts in support of the application and let the court decide what the correct action will be. Do not ever make inaccurate law statements at the time of registration. This will result in the registration being invalid. And one example of an inaccurate law statement involves perhaps the changing of the date of death in order to make sure that this is a registerable document. A person can unilaterally sever a joint tenancy upon the execution of a transfer, but it must be done before the person dies and cannot be done in a will or testamentary disposition. And it is highly improper to use zombie deeds to help clients avoid probate taxes and fees. Finally, and LawPro regularly stresses this topic, the importance of taking contemporaneous notes when meeting clients is highlighted. In the most recent case, the judge accepted that the lawyer's notes were necessary and reliable evidence to support his argument. We recently had a unique zombie deed question come up, and so I'm going to go over that one very briefly now. The sole director and shareholder of a corporation signed an acknowledgement and direction to register a charge and died the next day, prior to the charge being registered. Is this a zombie? In this example, it's not a zombie deed, and this comes straight from the Director of Titles. For a corporation, only dissolution constitutes death. A transfer or charge after dissolution is a zombie, and they do register these, believe it or not, but the whole board of directors could die before registration. So that was definitely an interesting topic recently, and Ray and I had a good conversation about that and then checked with Jeff Lem, the Director of Title. So that is the answer, that only dissolution constitutes death for a corporation. That's all I have on zombie deeds. Ray, over to you.
Thank you, Lori. Also, if you're trying to register a zombie deed because you're avoiding probate, there may be a first dealing that may be also useful. And the Director of Titles has issued a bulletin recently on first dealings and how they apply and when they apply. So check that out before panicking and going to try to register something that you should not. On to the fun part, taxes. Lawyers are not supposed to be experts in tax, and definitely we should be referring clients to somebody who is an accountant or a tax lawyer. But there are certain things that you have to know before when you're doing a real estate transaction. And there have been a number of important changes this year that we wanted to highlight to people just to make sure that everybody was on board. First of all, the HST treatment of assignments has changed. All assignments now are subject to HST. And although that seems to be a simple situation, there is a very particular way in which to deal with the transfer of the deposit. If it's done in a certain way, it is exempt from HST, which can be a significant amount. And so be very careful in drafting the assignment or reviewing the assignments that is dealt with. And there's a great paper that was done recently by a couple of lawyers, tax lawyers, and we have it on Avoid a Claim. And it is available, and I refer you to it in that case. Also, in Ontario, the non-resident speculation tax has been expanded to province-wide. It used to be very specific to the south of the province. Now been expanded province-wide, increased from 15% to 20% as of March 30th, 2022. Again, significant issue for lawyers. I know a lot of lawyers have just ignored it because it wasn't in their area. It's now in your backyard. Another issue that we have is the federal government promised in its budget, last budget, that they would tackle the housing issue. All governments seem to be wanting to deal with this. And so some of the ways that the federal government has come about is by putting in the Underused Housing Tax Act. And basically, it's a vacancy tax. It is effective as of January 1st, 2022. So it's in effect immediately. It's a 1% tax on the value of the real estate or the person's interest in the real estate. And the owner must report every December 31st of the year their vacant property. And then they have to pay by April, as we normally would pay our income tax, have to pay the tax for the previous year. It is a substantial tax. Again, something that would apply. There are some rules around it. I won't go into the very specific, but there is again an article that we have put out on this very situation as to what is a vacant unit, which vacant units, when do you report, how do you report. Interestingly enough, this was passed fairly quietly, and there is not very much documentation available. Presumably, the government is working on whatever the form, the report that we have to file, assuming that you have a vacant property. Another interesting issue, and this is in the specifically in Ottawa, but mention it because this is a tax that we've seen in Vancouver. Toronto has been playing with this. Ottawa has implemented it, and I think a lot of municipalities who are looking for money may very well be looking for this. So we have to be open to this. But Ottawa has passed a residential vacant unit tax. Again, like the federal government, 1% of the value of the property. It was in place as of May 11, 2022. The interesting part is that the tax is automatically added to the bill unless you file a declaration that your unit is not vacant. So it's kind of a reverse situation. So again, this is not necessarily something that you would be dealing with, but something you want to advise clients that they should be aware of if their property is vacant. Now, they do define vacancy as 184 days. So basically, 6 months of the year is quite a period of time. So you have a unit that's vacant for a couple of months while you're getting new tenants. That's not an issue, but it's something to be mindful of. Of course, they're residential properties. We're not talking about any other property, but a lot of people deal in residential properties. And so it's something that we have to be mindful of. The declaration has to be made. The other issue comes up is what happens if you close a transaction at the end of 2022 or in 2023, beginning of 2023 before April. Who's liable to register? I'm sure that the real estate agents are not going to be putting into the agreement that the vendors have to report or the vendors have to give a declaration. So this is somewhat going to fall onto the lawyers to follow up to ensure that was the property vacant? Do we need the information so that our clients, the purchasers, can now put in the declaration or have the information that they need to be able to be exempt of the tax. So another issue that's being worked through, the bylaw seems to put the obligation on the vendor, but again, if the vendor doesn't know about it, they don't do it. I'm sure somebody's going to be pointing a finger at a lawyer saying you should have checked on it. And that's the reason why we raise it, is a situation not necessarily where you have to collect the tax, or we don't collect the tax, but it is that the clients will have that impact, and they'll definitely be back. It'll be interesting to see what the title insurers do with this, because is this a item for the statement of adjustments that the vendor should have declared it, that the vendor is responsible for part of it? So, it'll be, is this something when you send a request for an adjustment that they're going to accept? And of course, are the title insurers going to back it up? So that'll be interesting. But to add, I think, somewhat insult to injury, the City of Ottawa has decided that not only do you pay a tax on your vacant property, but you must obtain a vacant unit permit if your unit is vacant. And it's a $1,703 annual permit that is required. It is required as soon as the property is unoccupied for 120 consecutive days. So 3-4 months, that's okay. Or as a result of a catastrophic event. So your client's property burns down, and now all of a sudden they have to go get a permit to leave it vacant until it's dealt with. There are other obligations under the provision also. There's a provision that they have to post contact information for the owner. So the neighbors can call somebody to complain about, I guess, the overgrown grass or whatever other conditions there are. So it's interesting. And they estimate that the the permit revenue that they're getting is going to be enough to hire 2 more bylaw enforcement officers to go around and look for vacant units. So this is not something that probably will go quietly. They'll probably be looking to justify their salaries, and so I think we're going to see this. So it's quite an interesting development. It'll be interesting because most cities look at other cities and go, "Oh, that's a good idea. Let's do it here." And so we raise it not simply because everybody here is practicing in the city of Ottawa, although now with our practices, we can practice anywhere. So if in Toronto, you have to know about this if you're doing an Ottawa closing. But also the fact that other municipalities may very well look at this and bring this into play. And I think that's something that we have to be mindful. There seems to be a great rash of attempts now to impose new taxes going forward. Now, final item I want to bring up on taxes is a new provision, again, federal government. They've now put in the purchase of residential, a prohibition of a purchase of residential property by non-Canadians. And so this is an act, it's in place, it's passed. And as of January 1st, 2023, for a 2-year period, non-residents are not allowed to buy residential property in Canada. So any residential property, the fine is $10,000 for the non-resident, but also there could be a court-ordered sale of the property if the non-resident has purchased. And although that, whether you don't agree with that as to whether this is going to save our housing situation or anything, that's one issue. The issue that has come up that we have concerned in the Canadian Bar Association Real Property section is drilling into is there is a provision in the offense section. Every person or entity that counsels, induces, aids, or abets, or attempts to counsel, induce, aid, or abet a non-resident to purchase, directly or indirectly, any residential property is guilty of an offense. That's what we do every day. We counsel clients. So what if a client comes to you and says, I'm a non-resident, I want to buy the property? Just by talking about it, sounds like we could be liable. So we are, the Canadian Bar Association is looking at going back to the ministry, back to the Justice Department to see what exactly the test is. What if a client comes in and says, no, I'm a resident, signed a non-resident the declaration? Is that sufficient? Is this like the Section 116 where just getting a document is not enough? You have to have reasonable due diligence to ensure that there are no red flags that lead you to believe that there may be a non-resident. That doesn't seem to be the test here. It seems to be just an arbitrary test. And so we're looking into this where the Canadian Bar is going to be setting it up. But if you have a non-resident, that may be interesting. I know that Judah has mentioned this, that this may be time to sell your property to a non-resident and get a better price because they won't be able to for the next 2 years. So maybe it's an opportunity to put your house on the market and get some of that foreign money. It'll be interesting to see if that creates a little bubble at the end of the year by non-residents who are aware of this. Obviously, if you have a client that's coming in that is a non-resident, closing is after January 1st. You want to change that closing date because that will not be able to be done. But also be mindful and be on the lookout for further information on the participation of the lawyer. This is troubling us at this point because advising clients in the purchase of a property is what we do every day. And it appears that if there's a non-resident, whether we know it or not, it appears that we may be getting ourselves into trouble. So let's watch that. So the takeaways to be looked at is, taxes are changing. There's been a significant changes in 2022. Some of it will be effective as of 2023, but still the provisions are there. We have to start implementing it. We may have to revise some of our procedures or some of the questionnaires, some of the questions we have in our questionnaires to be able to deal with these things. the government seems very much ready to add taxes to improve the housing availability. That somehow doesn't sound right, but there is a willingness. We have a lot of governments that are in trouble with their budgets because of COVID, and another source of tax may be a great way to start getting out of that hole. So let's be careful out there. Review the articles that we have. We have a number of articles, and whenever we have any updates, we try to put something out to the profession. And with that, Judah, back to you, or do I?
Yeah, thanks, Ray. I mean, you've covered a lot of ground very quickly around taxes. I think the bottom line as well is stay current, keep focused on what's happening, because a lot of this is happening in fairly short order. These are tax plans announced earlier in the year that are rolling out now. Short window until end of year for foreign buyers potentially, and so lots to keep apprised for going forward. So in our materials, we've sort of captured a point in time. So the zombie deed article is at page 5, but from page 7 through to the articles starting at page 16, all of our most current point in time moment about what's happening in tax land is there for you. And we encourage you also to subscribe to avoidaclaim.com. That's where we post updates as we learn of them, and that will help you as these matters unfold. But bottom line is, for sure, asking about foreign ownership, non-resident ownership, and learning about vacancy. Those are two key pieces that you're going to have to think about including in your onboarding and in your know your client questionnaires and due diligence. And so with that, I think I'm going to switch to the next topic. There are lots of great questions coming in about death and taxes, and time permitting, we may get to some at the end. But for now, let's speak about some of the other pieces that are happening, because in addition to taxes, in addition to some zombie deed fluctuations and difficulties that we've seen on occasion, particularly through COVID with deathbed wills and other issues that we've observed, we just generally, for the 98% who aren't on their deathbed, who are just in the process of buying or selling houses as one does, or other properties, it's a very bizarre time right now, and it's leading to other complaints that are coming through to LawPro. So Doug Bourassa is no stranger to the real estate bar and has this wonderful lens. And unfortunately, he's a litigator, and so he sees where the problems come. But that means he's ideally suited to talk to us about what's happening with real estate situations where there's a bind. So Doug, over to you for that topic.
Thanks, Judah, and thanks to everyone for attending today. Last time I checked, we had exactly 666 attendees, which is perhaps an ominous number, but the uptake on these programs is always spectacular. Oh, now we have 669, so I feel much better. My topic today is to walk through some of the litigation issues that I'm seeing in my practice around failed deals. And failed deals are everywhere these days. I had one 3-week period where every single day a new failed or failing transaction came across my desk. And I'm talking about residential transactions, but there's also weakness on the commercial side. The cap rates aren't there if the interest rates are going up. So it's a very challenging environment. And one of the big takeaways that I want to leave everyone with is that the most important question you can ask yourself is, and then what? What comes next? What is taking this position going to lead to next? Now, in isolation, when I put that out there, it's somewhat cryptic, doesn't explain itself. Hopefully, as I prattle on for the next 40 minutes or so, we'll put some meat on those bones and you can make sense of what I'm talking about. So imagine this scenario. Buyer puts in a bid, they bid blind. They haven't sold their own home, and they're fighting in a bidding war. That's the way it's been in Ontario real estate for the last 10, 15 years. Everyone's had clients that do that. That's how you buy a house in this neck of the woods. And for the last 15 years, it's generally worked out okay. Yeah, some people have overpaid, but as everything keeps going up, it turns out they sell their own house for more. What could possibly go wrong? Well, nowadays, with the market slowing or turning down, and I think the jury is still out on whether prices are actually going down. What's definitely true is listings are going down. Prices seem to be relatively stable, a little bit up here, a little bit down there. But what has changed is what the banks think these houses are worth. So let's walk through a hypothetical scenario. Your client blind bids, they buy their dream home. Everything's going to be great. They spent $1.5 million on this house, let's say. Let's imagine. In order to buy this house, they are going to sell their own home. And they think their first home is going to get them, I don't know, let's say 800 grand. It seems like a fair number. And they can finance all this. This makes sense. This is a purchase that they can do. So as closing approaches, two things happen. Number one, when they go to the bank and say, please give me a mortgage on my new home that I just bought for $1.5 million, the bank says, I don't think so. I think your house is worth 1.25. That's all we'll loan on. So all of a sudden, the buyers now need to come up with an additional $250,000. I call that Ray Leclerc money. And that's not the only spot where the buyer has a problem. The buyer goes to sell his own home, which he was counting on getting 800 grand for. He's only selling for 700. So he's getting it both ways. His financing piece is coming in low, and he needs to come up with another $250,000. And his sale piece is coming in low, and he needs to come up with an additional 100 grand. So in this little hypothetical scenario, all of a sudden this dream home has turned into an albatross where the purchasers are $350K short. And to make the situation a little more stressful, they've given a deposit of 100 grand. Let's call it their life savings, because that's usually what it is. So imagine your buyer. And if you are doing residential real estate transactions, I am sure each and every one of you has run into this. They can't get the loan they need. They can't sell their house for as much as they need. And their life savings is at risk. Pretty uncomfortable. Now, the surprising thing, the really surprising thing that I have learned dealing with these failed deals is that as you come to closing, everyone throws their hands up in the air. Oh, no, I don't have the money. I can't close. One would think that the legal issue is quite straightforward. You don't close, I take your deposit and I sue the pants off you. And I win because you didn't show up with the money, right? It doesn't take a fancy pants litigator to tell you that's how that lawsuit turns out. But, and this is important, winning that lawsuit oftentimes does not accomplish the vendor's goal. And here's where that question, and then what, comes up. Because the vendor is not a static entity here who can either sell their home or not sell their home. 9 times out of 10, that vendor has their own purchase coming, right? Transactions tend to happen in chains. They've sold this house because they're about to buy their dream house. Their life savings is at risk. They're not getting the financing. They're not getting the sale price that they thought they would get on their property. And so, yeah, as a lawyer, you can say, you have a great case here, vendor. You have a phenomenal case. We can sue the pants off this buyer. We can scoop their deposit and we can get a judgment against them. It'll take me 1 to 2 years. No problem. What exactly does a forfeited deposit 1 to 2 years later do for a vendor who has his own transaction to close the next day? What does it do for him? Jack squat is what it does for him, because his life savings is still at risk on his chained transaction. And here's what's so interesting about the incentives and the risks that drive how these things work out. The legal issue is not the interesting one. If you don't close, you're going to lose the lawsuit. We all know that. That's not what is driving the decision making. What's driving the decision making is that the buyer who is defaulting can offer the vendor something that no one else in the planet can. Speed. Right? The defaulting buyer can say to its vendor, I can't pay your agreed upon purchase price. I don't have it. I won't have it. But I can give you 85% or 90% of that in 5 days. No one else can do that. So if the vendor has their own follow-on transaction that they need to close, all of a sudden, they're faced with a difficult choice. Do I want to abate or reduce the purchase price on my existing sale so that I get 85 to 90% of what I bargained for and I can scrape together the rest to close my own purchase? Or do I want to risk my life savings and have a lawsuit against my buyer? Sure, I can get their deposit. Great. In a year or two, I can get a judgment. And I will tell everyone on this CPD, I could literally wallpaper the walls of my office with judgments on which I've collected $0. I don't think I do my clients any service if I pretend to them that an unsecured judgment is readily collectible. So from a vendor's perspective, if you have your own transaction closing, I'm not giving them good legal advice when I look them in the eye and say, let's go to litigation right away. There's nothing to talk about. Meet our price or go to heck. Because it doesn't answer that most important question. What happens next? Because for the vendor, if they have a follow-on transaction, their ass is hanging in the wind, just like the buyer here. They are in just as much stress as they can. And, the one thing I will reiterate time and time again, and again, I'm sure all of those practicing residential real estate are well aware of this. This is the most stressful thing people ever encounter. Even when it goes well, buying and selling houses and moving and changing schools and getting the mail done and dealing with lawyers. Oh, God, help me. It's the most stressful thing in most people's lives. I'll even tell you a short story to illustrate the point. Good friend of mine, he was selling his house at the same time I was. And I complained to him, this is so stressful. And he goes, it is definitely the most stressful thing in my life. And I said, are you sure, Peter? Because last year you had lung cancer and were close to death. Yeah, I know this is more stressful. So don't underestimate just how stressed out your clients are. And now to imagine that their dream home is turning into their worst nightmare. Residential real estate is emotional. And it is the biggest financial transaction in most people's lives. And don't be surprised that when it all goes to hell, they're scared, confused, excitable. in all of these failed transactions, whether I'm on for the buyer or the vendor, it is most likely that the best outcome is to revise the sale at a lower purchase price. You know, every case is different, of course, but usually that's where things end up. For the following reason: every other option for the vendor is worse. Again, forfeiting a deposit and getting an empty judgment in a year or two does absolutely nothing to accomplish the vendor's real goal. And the vendor's real goal is to be able to close his chain transaction and not lose his life savings. So if you think about it, what is the vendor going to do aside from the lawsuit? So yeah, he's got the deposit and he's got the judgment. He still owns the house, right? So what's he going to do? He's going to put it on the market and he's going to sell it for market value. What does that do for him? Right? Our current defaulting buyer is in a position where they say, the price I promised to pay you, I can't afford because the bank won't finance it because the bank says market value is 200 grand lower. What's the vendor going to do? He's going to sell it and the market's just going to give him that 200 lower number. And he can chase after the purchaser, sure. He can, hire yours truly to go after an unsecured empty judgment. And maybe you get a few dollars in a couple of years, but it doesn't help him close his own transaction. So as we think about this, even if the vendor's furious and says, this guy stabbed me in the back, I want nothing to do with him, let's relist the property, that doesn't solve his problem. It doesn't solve his problem at all, because he's not asking, and then what? What happens next? So he lists his property for sale. He can only get the market price because the market is what the market is. And this is key, it's going to take him 60 to 90 days. That's not going to do him a fat lot of good over here when he needs to close his next transaction in a couple of days. So that's why I say the defaulting buyer has something to offer that no one else on the planet can. Speed. Sure, it's less than the full portion he was promised, but no one else can offer our vendor that money. The vendor, I suppose they could go the bridge financing route, but that's going to get awfully expensive, awfully fast. And not many people are comfortable carrying 2 mortgages and a lawsuit with the hopes of getting some money later. That's a stopgap at best. And what does that bridge do for you? At most, it's going to get you far enough so that you can sell your current property at market value. That's all you're going to get for it, because it's worth what it's worth. So as you think about this problem from a vendor's perspective, they are immediately better off if they abate their purchase price and to the market price and add the deposit to it. So let's use those numbers I was talking about before, just so we can rationalize how the ball's bouncing here. Let's say the purchase price was 1.5. The current value of the property is 1.25. The deposit was 100 grand. All the vendor can do if he goes to market is get 1.25. That's all the market will pay him. If he sues the buyer, he can scoop the 100 and get what the market will pay him, 1.25. So it is economically rational for that seller to sell his property to the defaulting buyer for the market price plus the deposit, or using our math, 1.35, because that's all he's going to get a year and a half from now. and he'll have the pleasure of having defaulted on his own purchase. Now, I mentioned that real estate is emotional. How do you think that conversation goes when you talk to your vendor about how the guy who's just stabbed him in the back should get a deal on his purchase? That is a delicate conversation. Every time I'm acting for a vendor in those situations, the refrain is the same. This person is a schemer. They're a crook. They did this to screw me. This is all part of a scam. They can't be trusted. And with good reason. They promised to pay 1.5. They don't got the money. But I'm not doing my job if I don't lay out for them the consequences of taking the hard line, right? And it's that knock-on effect that is absolutely key. And that's the practice point here, which is just fighting with your own buyer and ignoring the fact that your client is about to default on his own purchase. That's going to get you sued, right? That's a situation where your vendor, if he or she does not appreciate the consequences because we haven't told them, you're liable to find yourself on the backside of a negligence complaint. Because that question that I laid out at the beginning, which is so central, and then what, is really what drives all of this. And it doesn't mean your client as a vendor is going to be happy. Don't get me wrong. Nobody is happy when their lawyer says, have I got a deal for you? This guy who stabbed you in the back, give him 150 grand. That is a delicate conversation. But here's the thing. It's better than all the alternatives. And that's really what we need to keep in mind as we're advising our clients. It's the option before your vendor client is not close the deal at the agreed upon price or simply sue. That's not the option set, right? There is the third way. And the agreed upon purchase price just ain't going to happen. So as soon as your vendor can understand that the turn in the market value will impair them as well on their ability to close, then you can get past the conversation of why am I doing a deal with this dirtbag to what are my reasonable alternatives to this. And this is a fascinating outcome here because it is counterintuitive. It is exactly the opposite of what the legal issue is. Again, the practical issue swamps and trumps the legal issue. The legal issue is dumb simple. I didn't need to go to law school to know if I don't pay the money, they can sue me. That's not particularly insightful legal analysis. And I suspect your clients don't need your advice on that either. They know that. Everyone knows that. But the advisory capacity that we're retained in is about something else entirely. It's about what are my reasonable alternatives here? What are my options? And if all my other options are worse, I should choose the less bad one. Now, that's a tough sales pitch. Don't get me wrong. Have I got a deal for you? It's the less bad one. But it still remains that your client's chained transaction is at risk. Now, I want to talk a little bit about how I've seen these situations evolve because they tend to have a sameness. And they're about lawyers positioning themselves for leverage. The buyer who knows he's, a day late and $1 short on this deal is itching to come up with some reduced purchase price. And unfortunately, we all have to do this wonderful dance instead of just talking about the economics, which is ultimately what drives the entire analysis, by the way. But we have to do this delightful dance where everyone starts puffing themselves up to try to bluff the other side out. The vendor says, we are retaining litigation counsel. We'll sue you right away. No abatement will be given. The purchaser says, we have grave concerns that you've misrepresented, I don't know, the color of the sun. I have grave concerns that you promised me I would be 10 feet tall after I close this transaction. You know, all this nonsense. You see this ongoing correspondence, and it's delightful. It's a dance. I don't know that there's any, I haven't encountered one where we found anything that was non-closing legitimate. But you find the buyer doing this for the very obvious reason they want to open the conversation. You know, I give a stupid example. I was involved in a file where some repairs had to be done prior to the closing. I forget what they were, but one of the complaints on the buyer side was the downspout wasn't sufficiently angled downwards. Therefore, we're not going to close. Now, come on, let's not kid ourselves. In order to fix the downspout, do you know what sort of abatement was required? One that magically marked the market price. Imagine that. It's almost as if the dance had nothing to do with the economics. And that's exactly what it was, of course, because it always is that. And, you know, I encourage you as you go through these things to keep in mind a couple of practice points. Now, it's mildly interesting that purchasers' lawyers can send these emails about these terrible misrepresentations. How dare you? But you can only go so far before you're just lying, right? And this is the practice point that we need to be careful about. If we are doing this dance, and if we are alleging deficiencies that require us not to close, they need to rise to at least a de minimis level of plausibility. I know I'm setting the bar awful low here. De minimis level of plausibility. Because ultimately, we do no service to this client and, more importantly, to our reputation with opposing counsel in the future when we throw up smoke that has no meat on the bones, if I can mix that metaphor. You know, and let's look at that example of the wrongly angled downspout. It was an artifice. Everyone knew it was an artifice. Of course, it doesn't cost $150,000 to re-angle a downspout. And the sooner we can get away from the nonsense and speak about the brass tacks of the economic alternatives, the sooner we can have a plausible conversation. And similarly, on the defense side, you have a client management issue. The client management issue, and I've spoken about this before, is that your client is furious and stressed out, which is a delightful combination. They're furious that the buyer is squawking and refusing to close, and they're stressed out because their own transaction is at risk and all their life savings is at risk. It's our job to make sure that those cooler heads prevail. You know, out of, I think, 15 to 17 of these transactions I've been working on, in 2 of them, the vendor proceeded immediately to litigation. And I don't think the outcome is what anyone wants. Certainly not what the buyer wants, but who the heck does the vendor care about the buyer? But even for the vendor, they took the hard line, thou must close. And I suspect that did not solve their problem at all. You know, now we're in litigation. Last time I was in court in Toronto, I went to set a summary judgment motion. So this is after the statement of claim, after the pleadings, the counterclaim, oh, heaven forbid. If you sued the broker too, because the deposit is tied up there, now you've got a third mouth to feed. Last time I went to schedule a motion, they were happy to offer me the earliest date, which was sometime in April 2023. We're skipping whole seasons now, right? Like forget fall, don't even think about winter. We're into spring, well, just about spring anyway. And that's the point here. The litigation alternative that we have to offer rarely satisfies the objectives of the client in a failing real estate transaction. And, I like suing people as much as the next guy, probably more than most of the next guys on this call, because I'm the only litigator. I make my living doing that. But I'm not accomplishing much for my client if, I'm a litigation hammer and I think every solution is a nail. That's not what I'm actually being hired for. I'm being hired to meet their objectives and to give them sage counsel on how to accomplish their objectives and get them as close to their desired outcome as possible. The ones that do end up going to litigation here are generally ones where there is simply no other alternative, right? In the hypothetical that I'm describing here, our defaulting buyer is selling his or her house for less than they wanted. Unfortunately, sometimes they can't sell that house at all. And in that case, the buyer has nothing to offer to the vendor, because that idea of 85% of the value coupled with speed, it ain't there. In those situations, there are no other alternatives. It's a simple lawsuit. It's a forfeiture of the deposit. You're caught in the litigation routine, and that's all that you can do. And so be it. Get the thing listed, sell for market, and see what you can accomplish. But so long as the buyer has sold a house, there are bargaining chips at play here that can accomplish some of the desired outcomes. And again, no one's going to be happy when they ultimately close their house for $150K less. Did you see what Jim down the street got for his house? What happened? Right? There's a lot of keeping up with the Joneses. But again, the question is, what happens next? What are the alternatives that I have? And, for vendors, it's actually a difficult market, because when I'm on for the buyer, I can look at them and say, yeah, you can go to market. You can get market price now, hopefully. And what happens if the market turns more? Maybe you don't get a buyer at all. Maybe the market price I'm offering you today is better than what the market will pay you in 30 to 60 to 90 days, right? Because for so long, we have been accustomed in the real estate game to prices moving in a single direction. Think of how many builders were happy to cancel transactions on the slightest provocation. Sorry, because they wanted to go back to market because the pre-built condo or whatever had increased in price. That's not happening these days, right? The old paradigm of market values always increasing has been smashed. Now, I said at the outset that, it's difficult to say if prices are going down or not. And as far as being a real estate prognosticator, I make a good litigation lawyer, and that's about it. Don't rely on my market assessment, that's for sure. But I do know what we have seen so far. And the biggest indicator that we've got is that listings are plummeting. On a year over year or even month to month basis, the amount of inventory out there is low. So you're seeing sellers sit on the sidelines because they don't want to sell at market price. Well, think about what that means in our defaulting situation. Our seller is forced to go to market because he has to buy his next house anyway, is forced to go to market in what every seller is telling us is a declining space. So again, the question of what happens next drives all of this. These issues are economic issues. They're largely not legal issues. The incentives that are driving the decision-making here have very little to do with the legal analysis of they didn't pay, you can sue them and get a judgment. And the other piece of sort of advice that I want to speak about is the when to involve the litigator piece. Because, I mentioned earlier that this is a dance that always gets done. And, if you're a residential real estate lawyer, yours is a volume game. You make your living on transactions that aren't a pain in the ass. Well, the transactions I'm describing right now are exactly that, and then some. They require hand-holding. They require, long, thoughtful, emotional phone calls, maybe some tears, probably some tears. I think in most of these, I've had tears, thankfully not my own, occasionally maybe a little bit my own. And the question for you as a residential real estate solicitor is, when do you involve the litigator? And I know this will sound self-serving, but the sooner the better. The sooner the better, for a couple of reasons. Number one, it is not necessarily what you were retained to do, right? You took your flat fee and you were retained to close a transaction. I don't like lawyers working and not getting paid. I suspect lawyers don't like working and not getting paid. It's important to understand the scope of your retainer and the advice that you've been retained to give your client. And, it can be a difficult, am I retained to negotiate an abatement? Maybe. Am I retained to threaten not closing and act in an advisory council as to the options available to my client on a litigation basis? Probably not. And as we all know, when we step outside our area of expertise, that's when we're apt to run into trouble. Plus, they ain't paying me for it. I found many of the referrals that I get, and this is not an advertisement for me, there's tons of excellent litigators who can help you with this. Many of them require mostly hand-holding, mostly delivering the speech that I've just delivered to you here today with almost no variation whatsoever from these lips to their ears. And I can deliver a different message from a litigation perspective than I think a real estate solicitor can. Next, the second reason why it's important to get a litigator involved earlier, signaling. I've described it as a little dance that we do, but taking the steps is part of the dance. And when you write to the other side, we've retained litigation counsel, and then all of a sudden something comes in on a different letterhead from a different lawyer. Oh no, now everyone gets all excited. But it's signaling that this matter is escalating, that my client is serious about pursuing this, whether it's the vendor side or the buyer side, I don't care. And we are ready to proceed. Part of what's happening here is a poker game, a bluff game, right? We are saying, here's my bogus deficiencies. I don't want to close. Give me an abatement to market price. And the vendor wants to sniff out whether they can actually close the damn thing. And part of the way we sniff that out is by how we signal, right? By undergoing the dance steps. Now, this is what LawPro most importantly wants me to focus on, is the advice giving nature. As a real estate solicitor, you should be cautious and reluctant to be providing advice on litigation topics, for the simple reason that you're not being paid for it, and you also haven't been retained to do it. I don't think that anything I'm saying here requires, a magician or some deep fanatical insight, but more fundamentally, the scope of your retainer is important. And if you're asked to exceed the scope of your retainer, you have to ask yourself whether you have the expertise to do so, whether you are retained to do so, whether you are paid to do so. And if those answers are no, why do you want to do it? Right? I mean, I get that it's stressful. Your client's in tears. This transaction's failing. But again, you've been retained for a purpose. I don't want this to come across as a sales pitch, because that's not what this is about. Instead, it's about a self-protection pitch, which is, scope of retainer defines the advice that you're going to be giving. And as soon as you start talking about what the litigation alternatives are and potential outcomes, you're stepping outside of likely what you were retained to do. So those two reasons, the signaling and the scope of retainer issue, are really how we should be thinking about when to involve a litigator. If we were in person, I would note that everyone's eyes are glazing over because I've been speaking for 40 minutes. Hopefully over Zoom, this has been mildly interesting to those in attendance. I really appreciate everyone who has signed on, and I appreciate LawPro putting this program together. All the best. Thanks.
Oh, thank you, Doug. I mean, look, listening to Doug speak, first off, the chat is lit up. The Q&A is lit up with notes of thanks to Doug. It's been an excellent chat to put the reality before us, because we're in a weird time right now where what might be correct in law is not necessarily where you're going to land for your clients. And that'll depend on each case. But with mortgage rates going up and the cost of housing going down, we're in a weird time where, at least according to today's headlines, October 6th, it's still more expensive to try to purchase a house today, even when the housing costs in some markets may be going down. And like Doug's condition there, I'm not a crystal ball magician. I have no idea if they are, in fact, going down some places. But certainly the cost of carrying your new property has gone up rapidly, and we don't expect that to change anytime soon. That leads to one other point I'd like to add before I take a couple more high-level pieces from Doug's incredible speech. One is that as the real estate lawyer, when you're on for a purchaser and you're doing the finance piece too, you're acting for the lender, you have a duty to both. And sometimes in this situation, things are going to change and it's going to get ugly for the individuals who have come into your office. But you have a duty to disclose material changes to your banking client, to your lending client. And so as things shift here, just keep that in mind. Because if it turns out that there's a deficiency and they say, oh, we're going to borrow from our in-laws, for example, that is a material change potentially from what the bank knows. And so you have that joint retainer situation. And as things shift in real time, you do have to tell the bank, because if things go sideways, or if that amount that was borrowed was actually a loan and it goes belly up, or something else happens that's going to materially impact the risk of a bank or other lending institution, they're going to turn around to you and say, why didn't you tell us of this material change? So keep an eye out for the changing situations that your clients are facing, but also recognize and remind them from the outset that when you are on for both the purchaser and the lender, there is information that must be shared across to both. Now, Doug mentioned a few key pieces here, and I just want to summarize a few of the takeaways from LawPro's perspective. One is that this has been a masterclass in negotiation 101. The real question here isn't what is just, it is what is the best alternative to a negotiated agreement. What's better than your BATNA? And in many of these cases, as Doug has pointed out, your BATNA is not litigation. Your BATNA is to figure it out for your clients. Now, when figuring it out from LawPro's perspective, that is hard work. And you need to make sure that your client understands the implications. Doug has pointed out that your clients may be in highly stressed situation, feeling that pressure, acting all over the map. Some of these messages may not land the first time when you have that chat. They may not land a second time when whoever is having this chat has that chat. Whoever is giving this information, whether it's you or whether it's a litigator who's been brought in, you're going to need to spend that time with your client. Spend that time walking through that speech that Doug gave. That will take a fair amount of time, and there will likely be follow-up, and there will be, the back and forth. Doug spent 40 minutes telling us about the scenarios and gaming them out. It's going to take about that much time, if not more, to game it out for your client and have time to manage the questions, to answer the questions, to simmer them down if they've hit a boiling point, to take a couple of minutes to ease off. And so there's going to be a lot of hand-holding here. And that's because we're there not just to try to close the deal, but we're there to also provide the best advice we can. And this is going to be an emotional ride. And so you are going to need to document your advice, because whatever is being heard may not be fully heard the first time, and it may not be fully heard the second time. It is very important that you provide those clients with the documentation, with a letter that explains the advice, and that you do this quickly so that they have it, because not everyone is an audible learner. Not everyone will absorb everything the first time by a Zoom call. And for down the road, it helps if there was any concern that you didn't advise somebody about something, or you didn't talk through the implications, or you didn't explain to them what would happen if you didn't do something, or you didn't explain to them how you might end up in litigation and lose more than just your deposit if you're acting for the person who's trying to get out of a deal. There are a lot of misconceptions that can happen along the way. And as you're negotiating, keep in mind that negotiating requires terms and conditions. And sometimes that litigator can be more comfortable making sure that we've endgamed out to make sure that this is a properly sealed up resolution. We've had a few cases come in where the real estate lawyer wanting to close the deal has renegotiated on the eve of closing, but it didn't endgame out what happens when certain pieces of that agreed to consensus, where that wiggle room hasn't been completely nailed shut. What happens next? And we've had those problems where it just delays the inevitable bringing in of the litigator. So I'm not saying that you need a litigator in every case. I'm not saying that not all real estate lawyers aren't competent to negotiate on behalf of their clients. I will say this, though. It's really important that whoever is giving the advice about a deal that's going sideways is open and candid with their clients about the situation they're in, that they document it carefully, and that they have negotiated to make sure that it is clear what the parties are intending to in order to see a deal close. And to do that, supports are available, including colleagues down the hall from you if you're in a bigger firm to go chat with a litigator, or to retain a litigator, or to talk with others involved in the deal to come up with the solution that you're going to paper and make sure your clients understand. So before we get to the next topic, I'm just going to ask Lori if she's got anything she'd like to say in closing on this as well.
Thanks, Doug and Judah, both informative. Doug, amazing, informative presentation. Thank you. I don't know that I have anything in particular to add, although it actually does sort of lead into the next topic. And I did want to reemphasize one thing Judah said. Don't forget your lender clients. It is far, far too easy, especially if there's more than one mortgage being registered on title, potentially by more than one lender. Far too easy to forget to communicate with your lender clients. Make sure that that is communicated in advance, that if something might not close, that all of the lenders know about it if you're acting for all of the lenders. And if they don't, let their lawyers know as well. It's super important.
Thanks, Lori. Okay, so we're going to move now from this area of trepidation to another one, unfortunately, but it's really important that we focus on real estate fraud as well before we wrap up today, because we are seeing rapid changes in the landscape and fraud actors are targeting real estate lawyers. For any of you who are in the GTHA, but outside the 416, you're being targeted right now to close deals across the province. You are among those being targeted. We're seeing a disproportionate number of solo and smalls in your areas being targeted. So take note. For other lawyers in the province, you're not off the hook. We're seeing this across the province, but I just wanted to mention for the 905 and surrounding, there are some serious frauds that are targeting you in particular at this particular point in time. But what we're going to talk about now are some real estate fraud prevention issues. We're going to start with owner impersonation or private mortgage frauds, and then talk briefly about wire frauds as well. And I want to emphasize that we have two separate full programs on fraud prevention, one from earlier this year and one from December 2021. Everything that we're going to cover today is covered there as well to go deeper. So if there are parts here that don't add up in this whirlwind overview, I'd encourage you to go there. Lori, let's start with you. Thanks.
Thanks, Judah. And yes, this is a very short amount of time to talk about these frauds. LawPro has seen a huge increase on the E&O side and on the title insurance side. And all of the other title insurers, I believe, have also seen an enormous increase in fraud on private mortgages and ID fraud. Generally, private mortgage fraud usually involves fraudulent ID. And the increase is such that we at LawPro are seeing claims daily, which used to be a much less frequent occurrence. So there's lots and lots to be done on this topic. And one of the things I would like to emphasize is that we really, as real estate lawyers, need to remember the basics, and that we need to catch what Ray fondly calls the low-hanging fruit. We need to make sure that we catch the relatively easy frauds. They are targeting private lenders and private mortgages. Often they don't own the property and they're pretending they own the property. And sometimes they even sell to unsuspecting buyers. Sometimes the tenant, sometimes it's a fraudster who has nothing to do with the property. The fake ID is often convincing, but there are some things you can look for. First, you're going to have two pieces of ID. Please check the pictures. Don't just take a photocopy or a scan of the ID and put it in the file. Please look at the ID. So make sure you look at it. If the pictures are exactly the same, that's a pretty big indicator of fraud. My driver's license picture and my picture on my passport, for example, are nowhere near the same picture, and everybody else will have the same experience. Please take a look at the picture and the date of birth on the documents. Oftentimes you'll see somebody who is much older or much younger than the date of birth indicated on the document. And of course, if the picture does not match the person sitting in front of you on the Zoom call or in person, obviously that is of significant concern. We need to make sure as well that the proceeds of the mortgage or the sale are directed where they need to go to the true owner of the property, etc. If you get, for example, a call or an email from what appears to be your client right before closing, directing you to send the money to a third party or changing where it goes, double check that. Pick up the phone to the client or the person you know to be the client. Double check the email address that it's coming from. Sometimes they change one letter of the email address, and that's how that fraud is perpetrated. I did see a question about the driver's license check with the government. Again, it is not perfect, but it is helpful to catch low-hanging fruit. If the government is aware that a driver's license has been stolen, it will show up in that database. So obviously, if the person doesn't know yet that their driver's license has been compromised, you may not see it there. It may look valid, but certainly there are lots of them in there that are showing as invalid. And that is yet another tool in the arsenal, if you will. If you have a new client and they are from a different jurisdiction than you are, then double check that file entirely. We are seeing people targeted, sort of as Judah said, outside the jurisdiction of the property often. So if you are in the 905 and there's something going on in downtown Toronto and it's a brand new client, it's not to say that it's not legitimate, but they certainly are thinking that there may not be as much knowledge about certain areas of the province by lawyers outside of that jurisdiction. And I am going to stop here. The materials have lots of information in them with lots of good sources and good sort of almost a checklist for things that you want to look for and look at. Feel free to call LawPro's fraud information line. We all answer, well, not all of us, but I answer calls, Ray answers calls, Judah answers calls, and we talk to people all the time. One of the things that I say regularly is that if it looks like a duck and it quacks like a duck, it's probably a duck. So if it looks like a fraud and it's acting like a fraud, it probably is one. It's a very uncomfortable situation to be in, but have the confidence to know you are not alone and LawPro is there to support you. Okay, Ray, over to you.
Thank you, Lori, for that. It is very much of an area of concern, and other area of concerns. And one of the things I try to remind people is fraud, and there are various flavors of it, but it comes in trends. And so when you don't see something, don't think that it doesn't exist anymore, because it may just be retrending. And so right now we see the private mortgage frauds and we see the wire frauds. That's the major trends, but that doesn't mean that all of the other frauds have gone away. You still have to monitor for those. But let's talk about the wire fraud. And the catchphrase we use is call before you click. So what happens here is that somebody's email account has been hacked. It could be the law firms, it could be the clients, it could be a third party. It's the agent, it's the broker, it's the appraiser. Somebody in there has been hacked. The fraudsters now are patient. They sit there, they have AI. They're listening for or monitoring for a payment. And when they see that payment, then they send out a wire instructions to pay. And people say, well, I'm okay if it's a direction, but I'm careful about redirections. No. Any payment instructions, direction, redirection, doesn't matter in what form it comes in, you should be very careful of, and you should be suspect of. And you should call before you click. And so the idea is you need to verify the banking information. We have a sad situation. Lawyer called us to tell us they called their client for closing. They needed $200,000. They asked the client to send the money, and the client said, well, I sent it to you 2 days ago when you sent me your direction. The client had received on the lawyer's letterhead clear instructions on where to send the money. They were wired. The client went to the bank, followed instructions, went to the bank, and sent the money to the bank as instructed. The banks don't verify names. They verify the account. If the account is right, they send it. Should they do more? Well, that's a different subject. What we have is reality. They will just follow instructions. And so client was out $200,000. You can imagine what that conversation was at that time. We had the unfortunate situation where a lawyer sent just about $4 million. Very busy transaction, had acted for the client multiple times. The client regularly switched accounts. So everything is being set up. It's a perfect scenario. What they didn't know is somebody was hacked. The instructions came to the lawyer. The lawyer knew. He admitted, said, I know, I should have called before, but it was late Friday night, thought I'd send it. Just under $4 million gone. Sole practitioner. Imagine that coming out of your account. What do you do? And so it is very difficult situation to discern. Lori talked about the fact that they change one letter in the email so that it looks like what you have. And you won't notice it unless you really spend the time. And really, who looks at those things? I mean, we don't, but we should. And if we don't, then the easy solution is call before you click. And so every lawyer should be aware. This is not just real estate lawyers. This is any lawyer out there that's sending funds by wire should be doing that, verifying. We had a lawyer call us to tell us that they receive a discharge statement from the bank, dealt with the bank on a regular basis. The bank basically, he got the statement, reviewed it, he was satisfied with it, gave it to his assistant and said, here, make the arrangements to make the payment. The clerk was curious because she noticed that instead of a check and courier, it was now a wire. And she just, thought, well, I'll call my contact. She called because I said they regularly dealt with this bank. Called the contact to say, we just got your statement and I'm just curious, you changed to wire payments now. And the bank said, well, first of all, we did not change to wire payments. And second of all, we did not send you a statement. But that statement was very real looking. And so again, call before you click. So everybody should be doing this. Everybody in your office should be instructed to do so. You should advise all clients to do so. In fact, anybody anything, you should call before you click. We have a document that's in the materials to be able to put into file. Again, it's a document situation. Who's documented? Who's going to do that search? Doesn't matter who does it. As long as somebody's done it, it's documented in the file. And before somebody sends a wire, they called before they clicked. Thank you, Judah.
Yeah, the resource that we've been disseminating since earlier this year, this fall, really helps you just walk through the steps to make sure that at file opening, you've got a phone number that you trust and that you can use to call across to the institution that you're going to wire money to, just to make sure that you've got the instructions confirmed correctly, the number of the person who's authorized the wire payment. So you use that number, you fill in that form, you follow it to a T. And if it says no further because something's not flagging properly, then you stop and you dig deeper before you send anything out of trust. This can save you from not just a report to LawPro, but potentially an over limits type of situation. I mean, think of that claim that cost more than $1 million. Depending on our coverage, it may be $1 million, it may be $250,000. If it's a wire that has nothing to do with a transaction, if it's an invoice payment, for example, or some other situation, there may be no coverage from LawPro because it may not actually be an error or omission in the provision of professional services. Wire fraud is hitting you regardless of what kind of practice you are in, regardless of what reason you are transferring funds. So if you just get into the habit of calling each time you're sending a wire, it helps to protect you. We'd also encourage you all to implement two-factor authentication on your own systems, and that has significantly reduced the risk of some sort of fraud that's tackling your system. I'm being breached right now by a spider of all things. So clearly, time to put an end to this spooky sessions where we talked about death, taxes, lawyers in a bind, and fraud. So thank you for coming today. We really are grateful for you spending time today with us. The program itself is eligible for an hour and a half of professionalism CPD credit. It's also eligible for LawPro's risk management credit, which can be claimed at lawpro.ca. The program will be available, some of you asked, it will be available for a replay at practicepro.ca/CPD. If you go to today's program, give us about a week and it'll be there. When the replay is ready, we'll send out a post on our avoidaclaim.com blog. So if you want to be in the know, you can subscribe there for updates and we'll let you know when this program is available. Our next and final session for 2022 with the TLA is our tips for corporate commercial lawyers on November 3rd. It's free to attend, like this one. It's eligible for 1.5 hours of professionalism credit and the LawPro Risk Management credit. You can register at the Toronto Lawyers Association website, and all are welcome. A few thank yous for today. Thank you, as always, to the wonderful staff at the Toronto Lawyers Association and at LawPro, including our Title Plus department, working behind the scenes to make today's event run smoothly. Thank you to LawPro's Title Plus for sponsoring today. We invite all of you to check out the new Title Plus website at titleplus.ca. We also have a new Title Plus podcast coming out, so stay tuned as well for the audio files out there. Thanks to Ontario's law associations who promoted this event, and thank you to all of our speakers for sharing your time today. TLA has actually made a donation to Lawyers Feed the Hungry on your behalf as a thank you for being part of today's program. Last request is to all of you who have come today, help us with our future programming. You're going to receive an email from the Toronto Lawyers Association for this program. It's going to have a short program evaluation. We ask you to please spend a couple of minutes completing it. It helps both TLA and LawPro to develop timely, helpful programming. Lastly, if you have other comments or you just want to reach out, you can give us a shout at practicepro@lawpro.ca. This concludes our program. Take care and thank you for joining us. Hope to see you in our November program. All the best.